The Copyright Act of 1976 first codified the doctrine of fair use, which allows others to use copyrighted material for things like research, news reporting, and parody without obtaining permission from the copyright holder. But what about before that? Over time, the permitted practice of abridgment or summarization of lengthier works began to give rise to the modern concept of fair use. In the 1841 seminal case of Folsom versus Marsh, we examine a critical point in this evolution. Jared Sparks created a 12-volume work published by Folsom, Wells, and Thurston entitled The Writings of George Washington. Copyright in this biography, which included several never-before-published private and official papers of the former president, was held by Folsom. Sparks's 7,000-page work was comprised of a first volume, in which Sparks provided an account of Washington's life, and 11 subsequent volumes containing Washington's letters and messages, along with Sparks's annotations and illustrations. Anthologist and writer Charles Upham later created a shorter 2-volume, 860-page biography entitled The Life of Washington in the Form of an Autobiography, which was published by Marsh, Capon, and Lyon. Upham's work copied over 300 pages of Washington's papers from Sparks's copyrighted work. In Upham's work, Washington's life story was essentially told by his papers, interspersed with Upham's explanations and contextualizations. Folsom sued Marsh and Upham in district court for copyright infringement, alleging that Upham's verbatim use of the protected papers constituted an illegal act of piracy. Marsh contended, amongst other arguments, that Upham's use of selected papers and portions thereof from Sparks's work was fair and justifiable.